Hi, I'm Nadine Udorovic, partner at Nichols Family Lawyers, a boutique specialist provider of family law services with offices in Melbourne and Geelong. Today we're exploring what happens to your property after separation. At this time of heightened emotion and vulnerability, decisions need to be made about splitting everything up, including dividing up all of the assets and belongings. In other words, couples need to try and work out who gets what. In family law terms, ensuring people get what they are entitled to after a relationship ends is called property settlement after separation. I should note that when family lawyers talk about property or the overall property pool, this doesn't mean just houses or apartments. Instead, in family law, the word property is used to cover everything you own plus everything you owe. Or to put it in another way, it covers all your assets and all your liabilities. It also includes superannuation. Your assets include actual property such as your home, plus things like cash, shares, jewellery, your car, your household goods, etc. Your liabilities, what you owe others, including things like your mortgage, other loans, credit card debt, unpaid taxes, car leases and so on, business liabilities and the like. It also includes your superannuation, whether that's a self-managed super fund or industry-held superannuation. How will the court approach the division of property after the separation? There is no distinct way that the court will divide property between two people. This decision is based on all of the evidence taken into account, as well as what is just and equitable in the circumstances. The general principles that are used when deciding on financial disputes after the breakdown of a marriage or de facto relationship are working out what the couple owns and what is owed, assets, debts, what they are worth, superannuation, etc. Looking at the direct financial contributions by each party to the marriage or de facto relationship, such as wage and salary earnings, and how those incomes were applied to, for example, mortgage repayments and other expenses. Looking at indirect financial contributions by each party, such as gifts and inheritances from families, any other loans or any other financial contributions that have come into the asset pool. And looking at the non-financial contributions to the marriage or de facto relationship, such as caring for children and homemaking and parenting contributions. Future requirements. A court will consider things like age, health, financial resources, care of children, and ability to earn income. And this is often where we see the biggest swing in adjustments and advice to clients, where we have to consider what the future factors are that impact the parties to a financial settlement. The way the assets and debts are shared between the former couple will depend on their individual circumstances, and no two financial settlements will be the same. The way your assets and debts will be shared between you will depend on the individual circumstances of yourself and your family. Your settlement will probably be different from others you may have heard about. Overall, the outcome must be just and equitable with regard to all of the circumstances that I've just spoken about earlier. At what point are debts and assets assessed? So the asset pool is calculated at the date that the parties are negotiating and or receive final court orders from the court or enter into consent orders. But the parties also often take into account and have to look at what the assets and debts were at the date of separation, because there's often a period of time between the date of separation and when parties are actually assessing their final property settlement. So this means that debt incurred after the separation can and is often included in the property pool for consideration. The fact that the debts and assets are assessed at the time of the parties receiving final orders may give rise to one spouse purposely wasting assets in the relationship with intention to deprive the other spouse of this asset or run up debt to mitigate the actual value of the asset pool. So what if one spouse purposely wastes the assets with an intention to make sure the other spouse does not receive it pursuant to the financial settlement? Well, if one spouse is misusing, lavishing or squandering the asset pool with this intention, this can be deemed to be wastage. That is, the spouse is dissipating the matrimonial asset pool. The court will consider a number of things to be dissipating the asset pool, including letting others use assets of charge for free. For example, if there was an investment property and removing a tenant from the investment property that would otherwise be paying rent and allowing a family member or friend, for example, to live in that property free of charge. Debts from a failing business, gambling debts, and this is often one of the biggest ones that we deal with. Selling an asset and spending the money. So for example, if there's a piece of real estate or a significant asset held in only one party's name, if that party takes steps to actually sell and dissipate that asset prior to a final property settlement and then goes ahead and uses the funds. paying legal fees from joint funds. So generally speaking, legal fees will need to be added back to the balance sheet of the asset pool. However, the court will not find conduct to be wastage if it is a reasonable expense. For example, continuing to run and maintain a business and spending business funds if it's legitimately for the benefit of the business continuing to run and be lucrative. Can final property orders be sought by a couple that was in a de facto relationship? Well, yes, a de facto relationship exists where a couple has been living together on a genuine domestic basis and have either, and there's many considerations and key factors that we have to take into consideration. So, for example, have they been living together for at least 2 years on a genuine domestic basis? Is there a child or children of the relationship? And would it be unjust not to recognise a de facto spouse's financial or non-financial contribution? So, for example, have the parties intermingled finances? Do they operate a joint bank account? Have they invested in assets or real estate together? Another factor is consideration as to the nature of the relationship between the parties. So, for example, what did their friends and family think of the relationship? Did they travel together? Did they attend family functions together? And what was effectively the intention that was being discussed between the parties? So, for example, what did each party say to each other about the nature of the relationship? And did one party believe that they were in a de facto relationship? So the Family Law Act contains mirror provisions that apply to both married and de facto couples. And the general principles used when approaching financial disputes are the same, regardless of whether the parties were in a marriage or a de facto relationship. Can final property orders still be sought by a couple that was in a same-sex relationship? Yes, although there is no specific mention of this in the Family Law Act, a same-sex couple is treated accordingly to the same provisions as married or de facto heterosexual couples. What is the difference between a financial settlement and a divorce? Well, a financial settlement is the formal division of assets and debts following a couple separating, and this can be sought as soon as the couple separates. However, a divorce is a legal termination and end of the marriage. A financial settlement can be formalised and finalised without applying for a divorce. The couple need only to have separated. And for parties to be eligible to apply for a divorce, they need to have been separated for at least 12 months. And then from the date of divorce, the couple actually then have 12 months to actually finalise their financial settlement from that date if they haven't already done so. At Nichols Family Lawyers, we're here to support you every step of the way. We offer you clear guidance and trusted expertise.